Welcome to the August edition of This Month in Payroll. I'm Rowan Geddes, National Leader of PwC's Payroll Advisory Practice. This month, we will focus on another case where a termination payment was paid late, the Helensburgh Coal case on genuine redundancies, 3 Fair Work Commission reviews into part-time employment, degree-qualified roles, and gender bias in our awards. We'll also look at the Ordinary Times earnings guidance released by the Australian Taxation Office and recap the Workforce Leaders Forum, which was held this month on AI in payroll. But first, late payment of employee termination payments. We spoke a few months ago about 2 cases, Joule versus Magnum Australia and Dorsch versus Head Oceania, dealing with late payment of an employee termination. Even though the late payments were self-disclosed in both cases, the courts applied penalties that were significant compared to the actual amount of the termination payment, 22.5% of the amount owed in the Magnum Australia case, and more than double the amount owed in the Head Oceania case. Well, it has happened again, this time in the case of Tan versus Commonwealth of Australia, Department of Defence. After Ms Tan's employment was terminated by the Department of Defence, she lodged a claim with the Federal Court, alleging contravention of the Fair Work Act over no less than 10 different adverse actions, ranging from the Department of Defence's incorrect refusal to allow Ms Tan to work from home or to work flexibly, to her supervisor's micromanaging manner of supervision, and through to her performance assessment. Each adverse action except one was dismissed by the court. The one action that was admitted to by the Department of Defence was that they had mistakenly underpaid Ms Tan for 2 weeks' pay in lieu of notice rather than 3. The short payment of 1 week's notice period amounted to $1,465 and was rectified within 6 weeks of its occurrence. The court accepted that the mistake was a case of human error from someone who otherwise carried out her role and tasks in a thorough and exemplary manner. However, they went on to say, what is not clear is why, in October 2020, a major Commonwealth department seemingly had in place no system, either human or technological, to check the correctness of termination of employment payments. In determining the penalty to apply, the Federal Court referred to a 1991 High Court decision, Trade Practices Commission versus CSR Limited, in which the Justice stated that the purpose of a civil penalty is primarily, if not wholly, protective in promoting the public interest in compliance. And also commentary from a 2005 Federal Court decision, which stated that the imposition of penalties in industrial law proceedings should no longer be approached with a light hand. Although the underpayment was minor and was promptly rectified, giving consideration to the above guidance, as well as the Department of Defence's failure to put into place review processes in the years subsequent to this issue being identified, the court determined that an appropriate deterrent penalty was 25% of the maximum penalty, being $8,325, for an underpayment of less than $1,500. For payroll functions, it is evident that the courts are more open to using civil penalties that are disproportionately large compared to the amounts in dispute, to encourage organisations to build in robust verification processes over their payroll function. Currently, this is evident particularly in the case of termination payments. However, employers should expect that failures to meet any part of the employee payroll process could generate similar outcomes, again, irrespective of the size of the error, the acknowledgement of the error, or the speed of the correction. Noting the pending introduction of Payday Super, there doesn't appear to be a better time for employers to initiate a proactive review of the payroll controls environment. A significant case was handed down this month by the High Court in Helensburgh Coal Proprietary Limited versus Bartley and others. This case clarified the critical test for a genuine redundancy under the Fair Work Act for the purposes of unfair dismissal. If the person's dismissal is a genuine redundancy, the person cannot argue that they have been unfairly dismissed. Helensburgh Coal is owned by Peabody Energy. Due to a downturn in demand for coal during the COVID pandemic, Helensburgh Coal restructured its operations, resulting in 47 forced employee redundancies. The affected employees challenged their dismissals in the Fair Work Commission, arguing that the redundancies were not genuine under the Fair Work Act because it would have been reasonable for them to be redeployed into roles otherwise performed by contractors. This case poses one significant question for the High Court. To what extent does the Fair Work Commission have a mandate to form its own assessment as to whether an employer could have made changes to his business to make a position available for an employee? In its decision, the High Court has unanimously held that the Fair Work Commission can undertake its own broad inquiry into whether an employer could have made changes to its workforce structure in assessing whether an employee is genuinely redundant. Within limits, the FWC doesn't have the power to fundamentally alter the business from which the redundancies were made. The decision has implications for employers going through a restructure of their business, especially when the business uses a mix of employees and contractors. Employers should be ready to justify their workforce decisions to the FWC, showing that genuine consideration has been given to redeploying employees who are protected from unfair dismissal, including the possibility of bringing work currently performed by contractors in-house. This Helensburgh decision is another challenge to the use of outsourcing as a way to manage employment costs, and comes on top of the cost challenges that businesses are facing as a result of the same job, same pay rules. Fair Work Commission reviews. The Fair Work Commission has also had a big month, with movement on 3 reviews that it is currently conducting. First, part-time employment. In the final report of the Modern Awards Review back in 2024, the Fair Work Commission noted that submissions had been made regarding part-time employment from a job security, work and care, and simplifying awards perspective. Accordingly, the FWC commenced a review this month of the provisions regulating part-time employment across 11 modern awards, including clerks, GRIA, General Retail Industry, HIGA, Hospitality Industry, and SHADS, Social Community, Home Care and Disability Services. The complete list of awards is on your screen. The objective of the review is to establish a standard model for part-time employment. Areas to be considered include definition of part-time employment, establishment of hours, how should they be established and how can they be varied, minimum and maximum hours and days for part-time employment, additional hours, circumstances in which part-time employees can work additional hours and overtime penalties implications. There have already been 25 submissions lodged in response to the announcement of the review, and the directions hearing is now listed for 3rd of September to consider the next steps and timetable for this case. We will watch the results with interest. Secondly, the Fair Work Commission has also initiated a review of classifications in select modern awards that require at least an undergraduate degree, or potentially a diploma qualification, to consider whether changes should be made to pay rates based on the value of the work performed, and examine whether some degree qualified roles have been historically undervalued, including gender-based undervaluation, noting that a much higher proportion of employees in professional occupations, 69.7%, are female. 22 awards have been provisionally nominated for the review, including higher education, legal services, live performance and professional employees. Again, the complete list is on the slide. And finally, gender bias. The FWC has previously observed that modern awards applying to female-dominated industries tended to include broader spans of ordinary hours compared to male-dominated industries and occupations. The implication of this may be gender inequality, because employees covered by female-dominated awards may be compensated less for their working hours given the span of hours provisions define when overtime entitlements are payable. To explore this further, a research project was undertaken to systematically identify and categorise the spans of hours in all modern awards, with a view to informing future consideration of whether these provisions contribute to gender-based inequality in working conditions. This paper, entitled Span of Hours Provisions, was released this month, reviewing the top 30 most commonly used modern awards and categorising them according to gender mix and 4 different levels of span of hours, ranging from no span of hours provisions to awards with expansive span of hours provisions, more than 14 hours. The preliminary analysis did suggest a relationship between a higher concentration of female employees and broader spans of hours, as 50% of the female-dominated awards fell into the expansive category, while only 10% of male-dominated awards did. Out of interest, the awards that were most gender-biased were the Hair and Beauty Industry Award, and the Educational Services Teachers Award for females, while for males it was the Plumbing and Fire Sprinklers Award and the Road Transport and Distribution Award. However, in a sign of how much work the FWC is currently managing, upon the release of the report, FWC President Justice Adam Hatcher issued a statement announcing that he has decided not to proceed with further submissions related to the report, noting how many significant award matters are before the Commission at the moment. Justice Hatcher suggested that he might revisit his decision in the future, although it would certainly not be before next year. In welcome news, the Tax Office has this month released a number of tables providing clarity as to whether certain employee payments count as ordinary time earnings and/or salary and wages for superannuation guarantee purposes. We've included a link on the slide. The tables align to STP2 reporting guidelines and cover everything from the normal, ordinary hours of work, casual loading, to the unique, annual leave loading not clearly linked to a lost opportunity to work overtime, long service leave paid under a portable long service leave scheme, workers' compensation, commissions. While comprehensive, the list is still non-exhaustive. In addition, employers always may have additional superannuation obligations under their award or underlying industrial instrument. Finally, this month, PwC held its latest Workforce Leaders Forum, discussing the impact on and potential benefits generated by AI in payroll. This very topical discussion touched on various matters, including exploring some of the existing AI payroll use cases that we've seen from a local and global perspective, the cultural challenges that need to be addressed as we adopt AI, and the governance, trust, and privacy matters to be considered. If you missed the forum, you can watch it on catch up via the link on your screen. And that's it for our August edition of This Month in Payroll. If you would like to revisit any of our prior updates, they are available on our website at pwc.com.au/payroll. And if you have any questions or need for support, please reach out to me or your usual PwC contact. Until next time, have a great month in payroll.